Advocate Ashish here, and I am welcoming to all of you to see my blog and my videos, and I am thanking to you all for keeping the support with us. And we have a case. We have a complaint case, and in that case, the criminal complaint was filed before the enforcement of BNSS, BSA, or BNS. As we know, the enforcement of that new enactments are 1st of July 2024. So, in our case, the criminal complaint was filed before the judicial magistrate on about February 2024. So, here the accused persons are summoned, upon which upon the consideration of complainant testimony and the witnesses testimony and the complaint itself and 202 inquiry. So now we we were confused that where the remedy exists and what is the remedy for the actual cause of action. So we read it very thoroughly, uh, for what provisions we could go to get rid of. So eventually, in that duration, the new ruling introduced by the Honorable Supreme Court of India in case of Parvinder Singh versus Enforcement Directorate, which was passed in, I think, it's May of 2026. So in that ruling, the complaint was filed by the ED and under the PMLA Act against the accused persons. So so the similar the question of law was there that the complaint was filed earlier to enforcement of new enactments, but in that ruling, in that case, the Honorable Supreme Court recognized the accused statutory right, or the recognizes it recognizes the uh, natural justice principles of natural justice, and in that case, the court, despite being the new enactments, in that enactment, that the uh, any appeal, any application or complaint or revision review which is pending uh, before the enactment, before the new enactment, then those all things will be covered under the previous law. Like uh, suppose you have a case which was filed earlier to the new enactment, so all the proceedings will be covered in that previous law or existing law. Uh, uh, during the, during during that uh, uh, during that period, the law was actually in practice, the procedure was in practice. So here the person here the motive behind the introduction of this provision, like 223 of BNSS, in that section, the one proviso is included, and this provision is definitely gonna help in to help out the courts, and to get rid of frivolous complaints, frivolous proceedings, malicious prosecutions, and also it will definitely gonna uh, uh, reduce the burden of cases. So, in that provision, while taking the cognizance, the judge is bound by the statutory uh, procedures or law that accused must be summoned before taking the cognizance. Cognizance is kind of that judicial magistrate has taken the judicial applied his judicial mind that the case is exist against the accused persons. It's kind of means uh, there is no we cannot say that it's a mini trial or a complete trial, but judge has to consider the complaint or the witnesses testimony, complainant testimony, and if does not if the court does not considers the all the materials which is produced before him, and he considers that to 202 CRPC inquiry is mandatory for actual for the existence of crime, for investigating or for something, for finding out the truth behind the complaint, then he can make the 202 inquiry before taking the cognizance. So in our case, the complaint was filed before the judicial magistrate, before the enactment before the new laws, enactment, enforcement of new laws. So here the Parvinder Singh versus in Directorate of Enforcement 2026 recent ruling of Supreme Court, which is gonna help out or in all the complaints where the accused were not summoned before the cognizance was taken. So here we have we are gonna file the revision for the impugned order, against the impugned order which was passed by the honorable trial judge, trial court, so that the all the summon orders uh, could be cancelled, or accused should be given the opportunity of being heard, which is in Latin terms the audi, which can say which we can say audi ultrum partem. So every person should be heard before the action is taken against them or against him. So it is really a nice provision or nice ruling, and it is like Pepsi Foods case in which is also recognized, a case which is also well recognized case, that all the judges, most of the cases, in most of the cases, they generally quit that judgment. In that judgment, uh, the court ruled that the it is very crucial that the judge should refrain from taking cognizance against the person which have no ingredients. Complaint has no ingredients, like uh, there is no case is made out against the accused persons, and making the accusations is really a serious issue, and the judge should not rely only on the basis of complaint and the testimony of the complainant or witnesses. So it should court must exercise his little bit judicial mind before taking the cognizance. So here, really, courts are really so. Honorable Supreme Court has really great sense or great powers or great interpretation of the statutes. Like BNSS is limited to the uh, cases which was filed at that time, like enforcement duration, like 1st of July 2024, not earlier. So that ruling which gives the persons the enforcement for the earlier committed or earlier filed complaints retrospectively. Like this kind of ruling is has a uh, significance for significance like ex post facto, and it has also the retrospective effect. So suppose if you have a case which was filed before the enforcement of new laws, then you can also avail this kind of benefit or interpretation. In the case of Sikandar Singh versus state of Punjab and Haryana, it's a 2025 29th of July 2025 case. In that case, the Punjab and Haryana High Court has also recognized the right of the accused of being heard before taking the cognizance against them, against the accused. So, Kerala High Court, Allahabad High Court, and Punjab and Haryana High Court, also, and Delhi, I think Delhi, all those honorable high courts have recognized that the intent of the legislature or object of the legislature, that for intent of the legislature for introduction of this proviso of 2023 BNSS. So now it is reiterated by the Honorable Supreme Court in his recent ruling, Parvinder Singh versus Directorate of Enforcement. You can also download it from the Honorable Supreme Court website, and also take the benefit that in your case, suppose if you have a case, and the accused accused has not been summoned or given notice before taking the cognizance, so you can take a plea that accused has right of being heard before taking the cognizance or before the case is made against him. So I hope this will help you out in your cases also. So thanks for watching. If you have any query, if you have any kind of query, you can just comment in this video. I will definitely gonna reply to you. So I hope uh, you understood my point, and let's finish this vlog or video, and keep keep in touch with me, and thanks for watching. I don't know how to stop this.